Good afternoon and welcome to the Affiliate Webinar Series. Thank you for joining us. My name is Kimberly Berry and I am the Senior Manager of the Affiliate Relations Division at ASHP. Today we are going to be covering the Board of Directors' legal roles and responsibilities. In this webinar we will discuss the important corporate and legal issues for boards of directors and their roles in nonprofit governance. When a board member assumes office, he or she must conform their conduct to certain legal standards and must be aware of and follow legal obligations attached to this board position. This webinar will cover the important legal standards and explain them, as well as providing practical examples around many of them. Presenting today is Fern Sapala, who currently serves in the capacity of Special Counsel to the CEO for the American Society of Health System Pharmacists and handles selected legal projects for the organization. Prior to retiring in 2014, Ms. Sapala was the full-time General Counsel and Vice President for ASHP for over 14 years and represented ASHP in various full-time positions for a total of 28 years. Fern holds a Juris Doctor from Catholic University and a Master of Public Health and Bachelor of Science from the University of Minnesota. Before we get started, we're just going to cover a few housekeeping items. In order to avoid background noise, each participant has been placed on mute. We will have a question and answer session at the end of the presentation. So please, if you have any questions, submit them for this session using the chat or question feature, which you can find on your GoToWebinar screen, usually found on the right-hand side of the panel. I will serve as moderator for your questions and will relay them to Fern as we go along. So at this point, I will turn it over to Fern, who will start the presentation. Fern?
Thank you, Kim. And Kim, can you hear me? So that'll be for the test question here. I want to say good day to everyone and thank you for calling in today. And I want to thank Membership and Affiliate Relations for inviting me to do this. And I want to thank all who have dialed in for taking the time out of your busy day to join us for 1 hour, because I know from personal experience how busy your day is. I do want to congratulate those who have been newly elected to your board of directors, and I have every confidence, and based on my experience, that you'll do well both personally and professionally. And I take it as an indicator, by virtue of you calling in today, that you really do take seriously your new role on the board of directors of your state affiliate, and that you want to do the best for them, both from your professional standpoint and personally. So today, well, the next slide that I have there is a disclaimer that I have to put forth as a requirement from the Bar Association. And essentially that just says that the views that are being expressed here today are my legal views and no one else's. What I'm going to do today, my objectives for today, are pretty simple. I want to provide an overview of your fiduciary duties as a board of director. I'm going to also comment about recent trends and some other issues that may give rise to liability, and I'll give you some basic strategies for avoiding liability. I do want to say the good news is not many associations get sued or their boards get sued. It's a pretty few cases, few and far between. You do see a few occasionally, but it's, for the most part, directors take their roles seriously, and they're really, as long as you fulfill your duties, you have immunity and you should be safe from liability. Let's talk about, what I'm going to talk about here is legal responsibilities. As a board member of a corporation, you have certain legal and ethical standards for your conduct as you carry out your duties as a member of the board. This standard is primarily grounded in state law. Every state has a corporation law. Now, some states have nonprofit laws, some states only have corporate law, but there's still the same standards for fiduciary duties. As I say, it's primarily grounded in state law, but I will tell you in the last 10 to 15 years, the federal authorities have also gotten involved with nonprofit governance, with the one of the top agencies being the IRS, and I will comment about what their role now is in governance when I get to that point. There are essentially three legal duties which I'm going to address: legal duty of care, duty of loyalty, and duty of obedience. In some states, duty of obedience is part of duty of loyalty, but in other state statutes, they break it out as a third subsection. The substance of it is the same, that's just a structural thing. The first duty is your duty of care, and that's essentially what we call the prudent person standard. What would an ordinary person in the same circumstances do? What it says in most statutes is that you're to exercise reasonable and ordinary care when making decisions or providing oversight for the organization. You're supposed to, as part of your duty of care, protect assets, financial resources, other proprietary information, so that you are making decisions which are sound and informed. So that's sort of the general philosophy behind duty of care. But how do you fulfill the duty of care? What are the practicalities of doing it? How are you going to know that you're fulfilling it? First of all, attend all the board meetings and committee meetings. If you feel prior to running for office you can't attend the meetings, either telephonically or in person, you need to think about whether you should run for office. Thank God technology is available to us today, but you know, sometimes I think in-person meetings may be more beneficial because you get to meet and know your fellow board members. It's important that you read and review all the materials sent to you prior to the board meeting, so that you know what the agenda is about, any background reports that are provided to you. Another way you know if you're fulfilling your duty of care is participating in the discussions, not merely, you know, when action is called for approval or not, to approve. It always concerned me when I saw board meetings and I saw 2 or 3 people who never talked. And I said usually something later in the meeting saying, well, it's important to be engaging in the discussion because that's part of your duty of care, participating. You bring an expertise to the table because you're setting the direction for the organization. Please remember that. Again, how do you know you're fulfilling your duty is you're looking at the finances. You're seeing what resources are being expended. And you want to make sure that you're exercising good business judgment about the decisions. Another duty that some organizations have is for recruiting or hiring the CEO for the organization. And that's an important function. Now, if you don't have a paid CEO, it's likely for some that you hire a management company. So again, you use the same informed decision-making to do that as well. Most state statutes have a requirement about reliance on experts because you're not expected to be all things to all people. So if you hire financial advisors or accountants or legal counsel or strategic planning individuals, and they are experts in their field based on their credentials, you can rely on what they are recommending. And the last thing, which I'm going to repeat several times here, is it is always beneficial for you to ask questions any point in time. Chances are other people are thinking the same question. If you've received a report and you don't think there's enough information in it, or you don't understand a certain item, please ask. That is an important thing to do. The other practical thing I do before moving on to the duty of loyalty is when I've been on boards, in fact, I'm on a small board right now, I keep a journal. If I review materials on a certain day, I make a notation, and it's electronic. I keep it on an electronic notepad. But I keep a journal that says on X date, I reviewed materials. On X date, I was on a phone call. On X date, I went to a meeting, that type of thing. And then after the meeting, I sort of summarize the fundamental actions that we're taking. Oh, we did this. We approved new painting for the building or something. You know, I just sort of have notes so that when I review the minutes later, I'm looking for those same items. So that's sort of a practical thing I do. Some people don't want to do it, but that's okay. You just want to have things to know that you have some evidence that you've been doing certain things. Okay, duty of loyalty. Your second duty is the duty of loyalty, and that's saying you're to pursue the best interests of the corporation and its membership. That's what your undivided allegiance is about. You have to put the interest and mission of the organization first. It is not really about anything about external, professional, and personal activities. You can't have divided loyalties here. And part of what duty of loyalty is about is, first of all, managing and minimizing conflict of interest, and secondly, maintaining confidentiality of information. These are really the two big items. Conflict of interest. Overall, I just want to say conflict of interest analysis is situational analysis. It's not a cookbook. So you do have to look at the facts and circumstances of each situation. A general definition of conflict of interest, and there are many, is really a personal or professional interest that may influence a decision of a director for the organization, and also create some kind of unfair advantage or disadvantage to some outside party or organization. One thing that is very important for an organization to do is to have a formal policy and procedure on conflict of interest. And this policy should be specific enough that it manages and has a process for addressing potential conflicts of interest of the directors on the board. First of all, there should be what I'll call it periodic disclosure. I would say prior to taking your office, there should be a report form that you complete, which outlines all your professional and external activities. And then when you come on to the board, there is a roundtable discussion of all those disclosure reports. One additional thing I would add about the disclosure report, if this disclosure can be done prior to slating candidates for office, I would try to do so, because then you get ahead of any potential conflicts and you can either discuss them beforehand and have some decisions made about how they will be handled before someone is slated. I think it's a little more difficult to handle conflicts of interest after the fact. Now, what kind of processes are in play if it's decided by the board that someone has a potential conflict of interest here? Usually what you see in state statutes, but even now they've gotten more expansive, a person who has a conflict or a potential conflict would refrain from voting on a particular matter and or not participating in the discussion about a particular matter if in fact they were determined to have a conflict of interest. A very common example I saw when I was at ASHP in a full-time capacity was when they talked about accreditation of residencies, and they're going through specific programs. Individual board members whose program was being discussed didn't say anything, and they didn't vote. They were just recused from participation. And I will say the minutes of the meeting also indicated that. So there's that strategy. The other strategy for addressing conflict of interest is an individual may decide to withdraw from an activity for the duration of their board service, depending on what it is. And then sometimes I have seen where a person either decided not to be slated for office, or when this arose subsequent after they began their term, they resigned from the board. It just depends. I will tell you, it is truly situational analysis, but these are the array of options that arise when conflict of interests are potentially identified. The other thing I have there is about perception is reality. Something may not be a conflict of interest, but someone reading about it or hearing about it may say, well, I think it is a conflict of interest. So if someone in the audience, especially for speaking engagements, thinks you have a conflict of interest, the fact that it may not be, their perception is you do. I always say to folks, would you want this information disclosed on the front cover of your association newsletter? Or would you want information disclosed on your local newspaper? That's sort of how, what would the public say or your membership say if they knew? Hello? Kim?
Yeah, we can still hear you.
Okay, I thought someone was talking. I thought I heard someone. I didn't know if they were asking me a question. I'll keep going. Kim, just as an interruption, I will tell you, it's good that you can hear me. I still can't see the slides, but that's okay.
We're on point with that.
Okay, great. The next slide is about some specific activities that give rise to conflict of interest questions or issues, and a lot of them will be very familiar to all of those who are dialing in. One is participation in selected educational activities and programs. Many of you, I have no doubt, provide CE seminars or give lectures, that type of thing. If you do that type of thing, it's important that all that be disclosed in your disclosure report, and then the board collectively can decide if that's something you should continue to do or not. What I've observed over time is sometimes when you do CEs, there's all this disclosure. You know, they say, I'm the director of XYZ pharmacy department, and by the way, I'm also president of the board of the state affiliate. I think sometimes audience members have a hard time dividing those hats. They'll remember that you were a member of the board. They may not remember your professional capacity, and they'll start to wonder, is she speaking for the organization? So I just offer that as an aside. Certain publishing opportunities also present potential conflict of interest, because it's not uncommon for someone to have a contract with a publisher and paid to write portions or all of a pharmacy-related practice book. Depending on how long you've been doing it, you may or may have to halt doing that for a while, or if it's a really long-standing publication, there are ways to sort of insulate that activity. You can talk with the editor of the book if that kind of situation comes up. I think it goes without saying that while board member, you should not have to take any gifts, gratuities, or remunerations from anyone, because usually they're giving them to you for some reason. They're looking for something. Another thing that I think is often interesting is as soon as someone is elected to the board, they get all these requests from other competing and non-competing organizations to either come and give lectures, or how about would you like to have a seat on our board of directors too? You have to be careful here because you can't divide your loyalties. You need to wear the hat of the affiliate chapter, and your allegiance is to that, not to something else, not an organization. Consulting arrangements are another thing within the industry which may give rise. Now, I am aware that some practitioners are full-time consultants, and if that's the case, then that has to be managed as well. When I had a board member who was a full-time consultant, they segregated their activities quite specifically to avoid some conflicts. Participation in external focus groups and advisory boards. My general view about that, and that's generally run by the pharmaceutical industries or other tech industries, I would try to put that off until you are no longer on the board. And the final thing I have, certain use of social media. This is a whole lecture unto itself. What I would ask boards of directors to do is to have a formal policy on the use of social media, what is appropriate for board members to be commenting on, and some criteria, because I have seen that get folks into issues and problems because they're saying one thing on their personal platforms and another thing on another platform. So I think you have to know in advance how social media is going to be used, whether it's Facebook, Instagram, LinkedIn, Twitter, all of those, so that you don't have a conflict coming into play. But a formal policy and procedure is important. Confidentiality, that's, the boards deal with a lot of sensitive and confidential information, and you just have to remember you should assume that nothing is disclosed unless there is a public statement about it. And that includes using your email. It's so easy to forward messages that you've received, and you will get a lot of inquiry from members saying, oh, what happened at the last board meeting? And of course you're excited and want to share that. You just need to think twice before you answer the question about what happened. I do recommend that every board member sign what I call a non-disclosure agreement at the front end of their term of office on the board. And essentially it's just saying that you won't disclose confidential information or proprietary information, that you will keep those things confidential. Duty of loyalty is how you fulfill it. I think I've talked about most of this. It's important to have a policy and procedure on conflict of interest. You participate in that process, and there should be an active assessment by the whole board of what you have in those non-disclosure agreements. It's not one person deciding, it's a collective decision. And please be sure to maintain the confidentiality of information. The last duty is duty of obedience, and that's pretty simple and straightforward. You as a board member need to make sure that your organization is in compliance with state and federal laws. And secondly, it has to also be in compliance with your organization's Articles of Incorporation, bylaws, and board policies. If you have not read your governing documents, I would strongly recommend that you do so, because it'll tell you the purpose of your organization, what activities, what component groups, how you're structured. It's important you know that. I recognize it's not very interesting reading. It's dry, sort of legalistic language, and at times can be so boring. But it's important you know what the structure and parameters are that are contained in your bylaws, so that when you make decisions, it if there's anything that's not allowed, you won't fall into that trap and then have to backtrack. A lot of organizations are going through a regular review of their bylaws, because in many ways they're too detailed and restricting. So if your organization hasn't done that in the last 3 to 5 years, it's something to consider having done. And then I have that comment there about avoiding negligent and fraudulent actions, which is pretty all-encompassing. You just want to avoid anything that really is outside the framework of the law. How you fulfill your duty of obedience, I think I've sort of said these things. You know, make sure that whatever actions you take are in compliance with the law and your bylaws. You want to make sure there are policies and procedures in place which help you meet your legal requirements, whether it's financial disclosures, filing Form 990s, personnel policies if you need them, financial policies. Be sure you have all of those policies in place. I think on the affiliate website that ASHP has, there's a list of policies that are important to have, such as conflict of interest, non-disclosure, antitrust, whistleblower, those types of things, because it's important that financial policies, it's important to have those. And then, as part of your duty of obedience, be sure you make available, pursuant to law, any tax-exempt forms that you have. People can ask you for those. There may be other federal and state required reports that you need to make. More states are requiring their own reports in addition to the IRS reports that are filed. That sort of takes in your fiduciary duties, those 3 duties that I've described. My next slide is really about recent trends for boards of directors. I follow the legal literature and the legal newsletters, as well as the association management papers. And some of these are the same and have not gone away, but some are continuing. One thing is there's a perpetual demand for documentation of deliberations and minutes and decisions. They want to be sure that the board has had an active discussion about an issue. Also, there need to be board minutes that are accurate. You know, not a transcription, but board minutes need to reflect what happened at the board meeting. And if one thing occasionally that I see is that board minutes are 5 months behind, or they haven't been timely prepared, it's important that they are prepared in a timely fashion and that you review them fairly promptly to make sure they're accurate. I see a lot of commentary about that. Again, read and know what your governing documents say, because occasionally you might get a question about, does the governing documents, do the bylaws allow this? A new issue, which is not new, but it's certainly gotten prominence, is fostering diversity in the composition of your board. At a minimum, I would say you need to be looking at what's the composition of your membership. Is your board also reflective of that? Is there other cultural diversity? Because there have been some studies now and reports that say when your board is diverse in its composition, you get better decision making. So something to give some thought to. Conflict of interest still is a large issue in the literature, and there has to be active management and resolution of any potential conflict of interest among members on the board. I continue to see, this last item on this slide is the demand for greater level of accountability and transparency regarding governance and management practices. That doesn't seem to be going away. The IRS is asking for more and more about that. I think state-level governments are also asking for more reporting, and even your own members. They want to make sure that what's going on is fairly transparent. This doesn't mean disclose confidential, sensitive information publicly, but it does say that you're engaging in sound decision-making. My next and final section is quickly, you'll keep track of the time here, selected legal issues that seem to always come up in one way or another. The priorities change, and I'm just going to touch briefly on them because more of an awareness that they're out there. And the first one is apparent authority. And that's one reason I say to read the governing documents. The governing documents, or sometimes a formal policy, outline who speaks for the organization. Primarily, it's the president, or in the person's absence, they will have some kind of vice chair of the board, or they will delegate another board member. But there is a person who speaks for the organization and who can authorize actions or respond to inquiries. So it's important that that person is doing it. It can't be sort of simply delegated away to someone who's not on the board. Use of technology, that keeps getting larger, as we all know. You just read the papers and you see the issues. Use of social media, I've commented on that. There should be a policy and procedure for board members regarding the use. Cybersecurity and data breaches, what can I say? We all know what happened with Equifax in 2017 with a massive data breach. Now, I recognize that perhaps the state association is much smaller, but you may be outsourcing data to the cloud through some third-party vendor. Be sure in whatever contract you signed, there is addressed the issues of what happens, how is data recovered if it's hacked? What about privacy concerns? What protections are there for the data that's being outsourced to the cloud? Now, if you maintain data on an in-house server and don't outsource, you still need to be sure what are provisions are in place. What's the data security system that you have? What are you going to do if something happens to the server and you have to recover the data? This whole issue of cybersecurity is very crucial today, and it's very important given how extensively all of us use technology. I can't minimize that. Also, I threw in here use of personal devices. It's probably likely that you're using your own iPhone or laptops for work-related purposes. If you're doing so, be sure the device has current virus software, that there are appropriate safeguards in place for the use. But I do say caution how you're using it. And perhaps the board will consider a policy for the use of personal devices and for what data can it be used and for what data can it not be used. Contracts, contractual matters. Everyone has some use of contracts, and these contracts bind the organization. So be sure whoever is signing them is authorized to sign, and the board can designate a board member to sign, or if it's a management company, you're authorizing the management company. But any contract needs to have the relevant provisions for protecting the organization. It should not be one-sided. They need to be read and analyzed. Is the contract in compliance with all state and local federal laws? And if there is some penalties or liability to the organization, be sure that the contract clearly outlines what specifically they are. If you have a hotel contract or a restaurant contract or something involving financial penalties, you want to know in advance what's going to happen if that penalty is invoked. And any language that's vague, you should reject and say, I want something specific. But again, contractual matters are a whole nother webinar. Maintaining tax exemption. That's getting more important, not less important. Be sure whatever version of the Form 990 that you file is being filed. I'm sure many of you know that if you don't file for 3 years in a row, you lose your exemption and you have to start over and apply all anew for tax exemption. One thing, unrelated business income. If you have unrelated business income, you should be aware, and whoever's doing your accounting, the new federal tax law has a provision in it that's going to have unrelated business income calculated on a more transaction-by-transaction basis. Right now, unrelated business income is usually aggregated, and the numbers are crunched that way. As I understand from seeing summaries of the new tax law, the unrelated business income is going to be calculated more specifically. So I offer that just as a something to look into if it's relevant for your organization. There will continue to be nonprofit tax quote reforms because revenues are at the federal and state level are pressed. So I'm seeing at the state level a review of sales tax and use tax exemptions that many nonprofits enjoy at the present time. And so you should be aware of that. If you own property where your offices are housed, states are looking at property tax exemptions as well. So this whole idea of maintaining tax exemption is getting attention, and I don't think we've seen the end of that at all, both at the federal and state level. Other issues, and all I'm going to do is go down the line because these are unto themselves. Antitrust, that's sort of the rules for doing business. The fact that you're a nonprofit doesn't exempt you from federal and state antitrust laws. You should have a policy about doing business. Intellectual property matters. I'm sure everyone has written and printed materials and electronic materials. Hopefully you are putting into place protections, copyright protections for those materials. The environment today for employment and labor law and vendor practices is, for the most part, in flux. A lot of things that were put into place a few years ago are now being reversed. It's a whole topic unto itself, but I just sort of bring it to your attention in case those are issues for you. If you are involved in any joint ventures and subsidiary arrangements, those too also have a host of legal issues which you'll need to pay attention to. All in all, you know, the question I often get is folks say, well, now I'm a member of the board of directors and I'm getting nervous. How do you minimize your exposure for a board of directors? First of all, I'll say by dialing into this seminar today, you've minimized your exposure because you're now aware of what your duties are. That's a very good thing. Board action, make sure board actions comply with federal and state laws and that they're in compliance with governing documents. I do occasionally see in governing documents that come across my desk for review where they're proposing to make changes which really aren't in compliance with the governing documents, and they just don't quite conform. So you do have to make sure that your documents are conforming and in compliance. Indemnification of directors. In the remote possibility that there is a claim against the board of directors for some action, usually relating to finances, there can be a clause in your governing documents, and I do recommend this, and we have samples, that you put indemnification of all directors. That is, if in the event of a claim, legal fees and expenses and any judgments will be paid by the association. Now, a caveat to that, it has to be within the scope of the board of director duties. If someone engages in criminal behavior, there is no immunity or insulation from liability. Somebody embezzles funds from the organization, which is usually an individual, there is no protection for that, and you become personally liable. The last thing, if you can afford to do so, is taking out director and officer insurance. Sometimes it can be pricey depending on the provisions, but it's something to consider if you can afford it, because that would then pay out any expenses or claims that might come against the board of directors and the organization. The good news here is these do not occur very often. Nonprofits usually have a lot of forewarning of some problems if they're having any, whether they're financial or documentary or reports aren't being filed. So it doesn't happen very often, which is the good news, but it's something to consider. I would say that to you. Finally, we're getting to the end here. I'm looking at the time. Okay. Takeaways from the whole discussion today, if you remember nothing else. Your role as a member and as a board of directors collectively, because remember, and I don't know if I said this already, board of directors act as a whole, not as individuals. Okay, your decision making is as a whole board. So as a whole board, you need to ensure that you are governing and setting the direction for the organization. That is what your role is, and you achieve that when you fulfill your duties: loyalty, care, and obedience. Be sure you're in compliance with the mission and the exempt purpose for which your organization was established, and you minimize your risk of liability against claims or anything else that may come against the organization, which is relatively rare, if you comply with your fiduciary duties. It's really that simple. And it really, when you perform your fiduciary duties, you're essentially shielding everyone on the board, members, from personal liability, so that your personal assets, your home, your own investments are essentially shielded as long as you can show that you've performed your fiduciary duties. And then the last thing I have there, which I always say to people, is ask questions. If you receive a report and it doesn't make sense or there's not enough information in it, ask for more. There are no stupid questions, and I'm a big believer of that. With that, Kim, I'm going to turn it over to you again and see if we have a few questions or comments that people would like to ask. And then if people have, I will offer, if people have questions after the fact, send them to Kim, and she and I will craft answers and get back to you. Okay, Kim?
Okay, thank you so much, Fern. We do have a couple of questions. One was more or less a request, and I'm sure that's probably being shared by others. We were asked if we had any samples of social media policy for boards that we could share. So I don't know, Fern, if you have any examples, but I think we have been asked about that more recently as social media has become, I think, more of an issue, especially as it applies to boards.
Well, you know what we can do, Kim, is we will, I think there are some samples out there. You know, we can get those and post those if you'd like on the affiliate website.
Sure, we can do that, and we
Okay.
can also share
We'll do that.
through. The other question, and I'm going to paraphrase a little bit, someone asked is, legal responsibility of all boards is obedience, for instance, compliance with federal or state laws. How could the Michigan State University Board go off the rails with regard to the Larry Nasser situation and claims? So basically, in this case, where the board was not obedient, and what are sort of the consequences? And I think that is still evolving. I believe that at the very least the Olympic Committee is being sued, or they've resigned, but I'm not sure about MSU. Do you have any information about that?
I can't, no, I really have no information. The comment I would have more globally, and I don't think I said it, the cases and causes of actions that have been brought against nonprofits are generally large academic institutions. Mm-hmm. And I think we're seeing that right here. Small nonprofits generally are pretty diligent about their actions, but I can't really, that's beyond my scope. I guess they have some severe problems, I think, up there. The other thing, I think I've seen before, excuse me, is if there's a heads up that problems are coming, don't ignore if there are signs that parts of the membership are asking questions either about certain expenditures or practices. Try to address these things sooner rather than later. If they're wondering how monies are being spent and it's not clear, try to address those questions as they arise. What happened up at Michigan is, I can't speak to that.
But I would imagine there's going to be continued fallout from that incident and the folks responsible. Another question that came in is, what is the difference between an umbrella policy and directors and officers insurance, and does ASHP offer directors and officers insurance through another company? I guess they're saying, I'm guessing or hoping, well, and I'm going to answer part of that because I'm not sure if the question is clear. ASHP does have a directors and officers insurance program that we make all of our affiliates aware of at the time when renewals start, and that probably process started in, it's already passed, so for those who have signed up. So if you say through another company other than the one we're using, no, we offer the insurance through Mercer. So that's the only company that we're dealing with right now. But in terms of an umbrella policy, Fern, if you could sort of differentiate between the two.
Well, the umbrella policy is that when ASHP, if my recollection is correct, went to Mercer because they were getting inquiries about D&O policies. And so what Mercer, I think, said to ASHP, and you can follow up on this, they said, well, we'll offer a policy, one policy that can be offered to all of our state affiliates. It can't be offered to anyone else, but it's sort of an overarching policy for any state affiliate that chooses to join it, and there is a fee for that. Versus if the affiliate, if it so chooses, and it could do that, could go out into the marketplace and see what other insurance companies are offering a D&O policy based solely on the specifics of that particular state affiliate. An umbrella policy pulls together a collection. It's based on the rate, I believe the premiums and insurance ratings are based on a collection of characteristics versus just one state organization. And supposedly that brings economies of scale. What is the current view about that through Mercer? I don't know the answer to that. But an umbrella policy is, it covers more organizations, not just the one. But they certainly can go out to other carriers and see what's out there. Okay. Do you think that answers it, Kim? Okay.
I hope so, and I'll follow up a little bit. The follow-up question was, does the affiliate have to offer it, or can I get it next year as an ASHP member? D&O insurance is a policy that covers all the directors and officers of your organization, so it's not an individual policy. So if,
correct.
For instance, yeah, so if I'm going to if the Ohio Society had a policy through Mercer that covers any and all of the directors and officers of that organization.
Correct.
So it's not something that you would purchase. Now, if different insurance or liability insurance that you have as a practitioner, I'm not aware of that. But
that's a different kind of insurance.
Right, and this is as it relates specifically to boards of directors. And I'm going to see if I can fit in. We've got a lot of questions here. What is your recommendation for periodic disclosure from association management or executive directors?
I think a good practice is that top management should at least yearly do disclosure in writing. Usually the accountants or auditors can put that process in place, but I think top management should do that as well, and that has been a practice that's been put in place. So that, and if there are any changes between the time that disclosure is made and 6 months after that, I think the person has an obligation to update their disclosure. But that's a very good question, because that's happening across the country in the commercial world as well.
I imagine. I'm going to slip in hopefully one or two more questions.
Okay.
In the event that the association is accused of not complying with its legal duties, what steps should be taken by the board, or what's the recommendation?
Well, I guess I have to say it depends. If the board of directors receives a formal legal claim that's been filed either in a federal or state court or an agency, if they receive such a document, I think the first thing I would recommend to them is contact local counsel and see how to respond. More likely than not, by the time you get a cause of action served on you, you probably had some indication it was coming. These usually don't come out of the blue. So I think if you sense you're getting questions from members about actions, this is where it goes to accountability and transparency. The board needs to have a plan for how they will address questions. But I think it depends on the severity and what stage such an action is coming. Certainly local counsel can help put together a plan. Something that associations get maybe before they get a legal claim or some kind of a lawsuit is they may get subpoenas in the mail or served by a process server. And I would say in that situation as well, contact some kind of local legal advice so that you can respond promptly, or at a minimum, determine if this subpoena is appropriate and what they're asking, that type of thing. But hopefully you've had some lead in to that this was coming about it.
Okay, great. Well, I think we've come to the close of our webinar. Fern, I just, on behalf of ASHP and the Affiliate Relations Division, want to thank you so much for your willingness to share this information with our state affiliates. And for those of you on the call, I want to thank you for your participation today. Again, this webinar has been recorded and will be available on the state affiliate website in several days. We will send you a link, and we really encourage you to share that with others in your leadership or who may have an interest via email or social media. And we will also make the slides available. Also, in the meantime, if there are any questions that come up, as Fern stated, please send me the questions and I will forward those to Fern, and we will get appropriate information back to you at that time. So with that, we are going to end the webinar. Thank you again for taking time out of your busy day, and enjoy the rest of the week. Thank you.